Hello and welcome back to the Florida Rights Institute informational video series. Today we're going to be talking about the Florida constitutional right of privacy, which is an overview of Florida's constitutional right of privacy constitutional provision. As always, the following presentation is meant for informational purposes only and is not intended as legal advice. Seek a licensed attorney if you need legal assistance. In 1980, Florida voters by general election amended the state constitution to provide Section 23, right of privacy. Every natural person has the right to be let alone and free from governmental intrusion into his private life, except as otherwise provided herein. This section shall not be construed to limit the public's right of access to public records and meetings as provided by law. The Florida Supreme Court weighed in on this constitutional amendment. The Florida Supreme Court weighed in on this constitutional provision. They addressed the standards for privacy constitutional provision in a case concerning parent consent for a minor's abortion. The court noted the importance of privacy and laid down some standards for the provision's application. The court said, the essential concept of privacy is deeply rooted in our nation's political and philosophical heritage. The citizens of Florida opted for more protection from governmental intrusion when they approved Article 1, Section 23 of the Florida Constitution. This amendment is an independent, freestanding constitutional provision which declares the fundamental right to privacy. Article 1, Section 23 was intentionally phrased in strong terms. Since the people of the state exercised their prerogative and enacted an amendment to the Florida Constitution, which expressly and succinctly provides for a strong right of privacy not found in the United States Constitution, it can only be concluded that the right is much broader in scope than that of the federal constitution. The privacy section contains no express standard of review for evaluating the lawfulness of a government intrusion into one's private life, and this court, when called upon, adopted the following standard. The right of privacy is a fundamental right which we believe demands a compelling state interest standard. This test shifts the burden of proof to the state to justify an intrusion on privacy. The burden can be met by demonstrating that the challenged regulation serves a compelling state interest and accomplishes its goal through the use of the least intrusive means. In short, privacy issues in the state of Florida are regarded under the review of strict scrutiny, the highest scrutiny that is reserved for protecting fundamental rights. As privacy is so strongly regarded, any issue that could be brought under this constitutional provision will be regarded with the highest burden against the state. The only difficulty is trying to get a court to view an issue as a privacy issue. Some privacy issues that have been noted include closure of court proceedings and records, donor information concerning AIDS-tainted blood supply, banking records, bar application questions concerning disclosure of psychiatric counseling, abortion, removal of nasogastric feeding tube from an adult in a permanent vegetative state, among others. In final summary, raising privacy issues under Florida Constitution Article 1, Section 23 is a potent way to bolster your case if the judge accepts the provision's application. Florida's privacy provisions are uniquely strong and offer a chance to meaningfully stop state intrusions should they arise. Thank you so much for being a part of this informational educational video series. Please subscribe to this channel, like this video and share it, and visit floridarights.org for more.